questions to ask yourself before preparing a will. Whether or not you hire an attorney to write your will, write one yourself, or have one written through a website, there are questions you should ask yourself and really take some time to think about prior to diving into the process. If you hire an attorney who charges hourly, knowing these questions and thinking about them prior to speaking with the attorney could save you money. Who will be the executor of your estate? The person you nominate as executor, also referred to as personal representative, should be someone you trust and someone that can handle the large responsibility. NOLO defines the executor as the person charged with protecting a deceased person's property until all debts and taxes are paid, and seeing that what's left is transferred to the people who are entitled to it. Responsibilities of executor are, but not limited to, the following. Locate the decedent's assets. This could be a very large task depending on the organization of the decedent. Manage assets. Open estate bank accounts, transfer stocks into the name of the estate, sell stocks, etc. Facilitate the transfer of assets to the correct beneficiaries. File will. Pay decedent's expenses using estate assets. Make sure all income taxes are filed and estate taxes are filed as applicable. Determine if probate through the court is necessary. The responsibility of the executor is huge. When deciding who to name as executor in your will, it should be someone that you are confident can handle this responsibility and that you know will abide by your wishes. You may also nominate backup executors who would serve in the event the primary executor is incapable or unwilling. Make sure the backup executors are also someone that you know is fit for the job. Remember that executor by law must be over 18 and someone who has not been convicted of a felony. Since the role of the executor is a large responsibility, it is important to ask the person before writing them into your will. Who will inherit your household contents? In most wills, your household contents will be referred to as your tangible personal property. This often causes confusion. Be aware that your tangible personal property is the household contents, but not the real estate property itself. You should decide who you want to inherit your household contents, as well as decide on beneficiaries who will receive in event that the primary beneficiary is unable to inherit. Many wills have a provision that your tangible personal property can be donated or sold, with the proceeds added to your residual estate explained below. You may give all of your household contents to one person, while also specifying specific assets go to another person. For example, you may want your spouse to receive all of your tangible personal property, except you want your daughter to have your diamond engagement ring. Who will inherit the remainder of your estate, also referred to as residuary estate? Oftentimes, the same people you choose to inherit your household contents will inherit your residual estate, everything except for the household contents. The residual estate includes money, residence, etc. Ask yourself who will inherit, and make a clear list of any specific bequests, if applicable. You should also think of several beneficiaries in the event a primary, secondary, etc. are unable to inherit. An important aspect to think about is if you want the children of a specific beneficiary to receive the inheritance in the event the beneficiary dies, or if it should flow to someone else. Who will be the custodian for a beneficiary under the age of 21? This may not be applicable in the event you do not have an individual under the age of 21 that is set to inherit, but if you do, then this applies. If you have a person named in your will under 21 that could inherit, you need to name a custodian. A custodian will be in charge of the assets for the minor until they reach the age of 21. Some people choose their executors, others choose the guardian they appoint in their will, or another person entirely. Who will be the guardian of your child? This is only applicable if you have a minor child at the time of the execution of your will. Ask yourself, who you would like to appoint as guardian in the event your spouse is unable. This is a huge responsibility, and like the executor, you should speak to the person beforehand about appointing them. And really take the time to think long and hard if this is the correct person to raise your child. Also choose backup guardians in the event the primary is unable or unwilling. Final thoughts. A number of other questions will come to your mind when you think about writing your will, but these questions should give you a good jumping off point to start collecting your thoughts. It is important to get the full names of all people referred to in your will for identification purposes. This seems silly, but you should make sure to get the middle names of all people named. You'd be surprised how many times this is forgotten.